Thank you very much. Can you hear me? Okay. It's a great honor to be here, and I appreciate you inviting me as part of your celebration. I was more excited a few minutes ago because I didn't realize that I could have later spoken on the future of dating, which I admit I'm 50 years out of date. But it's actually, my success at dating is exactly what I'm trying to convince you of, is the success of my marriage is I've kept this poor woman's expectations so low that I've been able to exceed it every year for 30 years. And I want to try to keep your expectations as low as possible. So I was asked to talk about the affirmative action cases. I'm going to talk about it, then I'm going to hijack it and make a hard turn to bring in some other issues related, in my view, to that decision. The Supreme Court, I want to first talk a little bit about the Supreme Court because I write for 4 different newspapers, and I've covered the Supreme Court as a legal analyst for NBC, CBS, BBC, Fox for the last 30 years. And one of my pet peeves about the coverage, and it goes directly into the affirmative action case, is the portrayal of the media of the court. And I'm happy to say for 30 years I've defended justices on both the left and the right of the court because I think that people are grossly unfair to the justices. It's not that I agree with what they often write. There's often cases where I agree with none of them. But they really do try to get things right. And there's often a tendency to look at people you disagree with and view them as just, vacuous ideologues and robotic partisans. These justices, every single one of them tries to get these cases right, but the coverage often distorts the truth. And that's one of the reasons why Justice Breyer, before he left the court, gave an interview, and it was to a fairly liberal interviewer, and the interviewer referred to the conservative majority and the conservative Supreme Court. And Breyer cut her short and said, it's not a conservative court. And it was really there was a shock. It said, how can you say that? It's in control of this conservative majority. And Breyer said, it's not. That's not how we rule. Most cases do not show an ideological division. We don't have intensely ideological debates in most cases. And in most cases, we don't have a way to predict how we're going to vote. That is, I don't know, and I'm in the conferences. It's not an ideological court in that sense. And that is certainly borne out by the statistics every single year. And I just want to share that before we get into this case, because we have had a stable conservative majority emerge. And there's no question that that has resulted in new doctrines that many people disagree with, including the Dobbs decision. That's where that consolidation certainly has its impact. Most of the cases are not part of that spectrum. The court only handles about 58 cases a year, which is a pretty good job if you can get it. It's actually fallen. It was almost twice that number. So that's the benefit of being a discretionary court. You can just pick up things you want to pick up. Virtually, all of the cases, 71% of the cases had at least one dissenting justice. Of the 11 6-3 votes, now, by the way, the majority of the decisions in the last year have been unanimous, just slightly below 50%, unanimous. Okay. Now, when you add to that the cases that are 8-1, 7-2, it is virtually all of the cases. There's only 11 cases that are 6-3. So one of the things that I always emphasize at the beginning is that's the reality. And when you look at those cases, including the 11 6-3 votes, only half of those broke along ideological lines. This court actually breaks up a lot. There is not a unified side in most of these cases. Now, it's true, in those core, or what they're called first principle cases, that's when you see the greater alignment. But Breyer was right. It is not, if you look at the cases, as rigidly ideological as people suggest. Now, that doesn't change the fact that people have very strong views against some of these opinions, and those opinions have huge impacts on society. But an example of that is, in Sackett, which limited the EPA's authority, that was unanimous. That wasn't a conservative decision. And I actually read an opinion once saying the conservatives in Sackett, limited EPA authority. It was unanimous. It was all of the justices agreed with the outcome. There was a difference on the standard, but by the way, the dissenters or the concurrence on that standard was led by Justice Kavanaugh with the liberal justices. And so even on the concurrence, it had people from both sides of the court. In the 5-4 Allen decision, Roberts and Kavanaugh joined his liberal colleagues. These are major cases. So I think the coverage is wrong, and I think we have to keep that in mind. It doesn't mean you shouldn't disagree with the court. I just spoke at the 10th Circuit, and the chief said something. He spoke before me, and he made a very good statement. He said, you should criticize us. We are the Supreme Court. We'll say things you don't like. But he says there's a difference between criticizing how we view jurisprudence and who we are. And it's certainly a difference between criticizing the court and threatening members. Now, technically, this is not, I don't think, the Roberts Court. Every court but one has been named after the Chief Justice. Does anyone remember which one? It's the FDR court. It's generally called the FDR court because that was the court when Roosevelt tried to stack the court. This is technically the Roberts court, but it really isn't. Roberts doesn't have that same gravitational pull. He is a swing, but he's not the real swing on the court. So let me ask you this, because I don't think you should just sit there and do nothing. And for all you students, you will be graded on this. Which justice do you think was in the majority the most in the last rounds?
Roberts?
Nope, not Roberts. Kavanaugh. Kavanaugh was in the majority the most. He was in the majority 96% of the time. 96%. What a kiss up. So goes to the coverage again. Listen to this spread and see if this is the court that you've been reading about. In terms of, I'm going to start at the ones most in the majority, right? So Kavanaugh's at 96, Roberts is at 95. That's the reason, by the way, Roberts is not the swing. The swing on this court is a combo. It's Roberts and Kavanaugh. That's the swing of the court. And they do vote together a lot. But then the third is Barrett. And who do you think the fourth is? Jackson. Jackson is the fourth most likely justice in the majority, followed by Gorsuch, Sotomayor, Alito, Kagan. And who do you think is the least? Who's in the least majority? Is Thomas. So the one that votes the least with the majority is actually the most conservative member on the court. Now let's get to this decision. And I always tell my students in my Supreme Court class that there's a funny thing that happens when major doctrines are set aside. And it sort of follows what I call Queen Margaret's rule. And in Richard III, Queen Margaret was asked by the Queen, Queen Margaret was the Queen Mother, was asked by the Queen whose twins were now in the Tower and would be executed or killed by Richard III. And she turns to the Queen Mother and asks, "Can you teach me how to hate?" And Queen Margaret says, "It's not very difficult. Think of thy babies were sweeter than they were, and he who slew them fouler than he is." Well, when it comes to precedent, we often do the same thing. We think of precedent as sweeter than it was, and those who slew them as fouler than they are. And the reason I mention that is that various doctrines have fallen the last few years, and some of them are legitimately going to occupy a lot of our debate for the years going forward, including Dobbs. But for example, on the Lemon test, in Kennedy, the Supreme Court shot the Lemon test on religious cases. And I remember speaking at this conference, and this professor objecting to asking a question and saying, you know, can you really excuse the fact that they killed the Lemon test? And I almost spit my coffee out, because for the last 5 years, we have all, on every part of the spectrum, only referred to the Lemon test with derision, and it almost was always in the same sentence with, it's dead. I mean, for the last 10 years, it's been considered dead. It was incomprehensible in many of these decisions. But it's part of thinking of your children as sweeter than they were. The Lemon test died years ago. So there was not life there that was taken. Dobbs is a different issue, but it's also something worth noting. You know, in Dobbs, the Supreme Court had been divided 5-4 on abortion for decades. And let's be honest, the majority that finally emerged in Dobbs, that's the same view that has been stated since Roe in 4 justice member dissents. I mean, it's the same objections. And every year, because I had to cover the court, we had to debate whether Roe would survive. And by the way, Roe died earlier. Okay, Roe didn't exist when Dobbs came around because Casey got rid of Roe. And so Roe was unsustainable and was replaced by the left of the court on Casey. So that doesn't mean that the Supreme Court was right in Dobbs. I think that there's really good faith arguments here, and this is a very difficult question for us as a nation. But I think that we have to be honest about what came before Dobbs as we evaluate what's going to come after. But that brings me to affirmative action, and this is where the Queen Margaret's rule really kicks in. The affirmative action cases were an utter and absolute mess since Bakke. And yet, I read all of my friends are writing columns saying, I cannot believe that, you know, the Supreme Court just declared that racial factors in admissions are discrimination. It's just like a whole new world. And I don't know what world they've been living in because, you know, I was a young intern standing outside the court 44 years ago when the Bakke decision came out. And I remember standing there as the whole world seemed to be coming to an end as thousands of people were protesting on both sides. But affirmative action, according to the court in admissions, died with Bakke. The court ruled that you can't use affirmative action in admissions, that it is a form of discrimination, period, full stop. Now, what the court added was that in the plurality part of the decision, Lewis Powell said that that doesn't mean that race can't be considered as one of a number of diversity elements. And he didn't explain how to do that, but he said that is a permissible use for the purposes of diversity. What followed was almost 5 decades of nonstop litigation. And let's be honest, the universities took that exception and they reproduced the result in Bakke. And I say that not because I'm hostile to diversity policies on race, I'm not. But we do have to be honest as academics. Universities found very clever ways to get around Bakke and the later decisions. But these cases never had a good EKG. You know, when the court decided two cases in tandem, Grutter and Gratz. You were dealing with the University of Michigan's college and law school. And in Gratz, the court ruled against the University of Michigan on the use of race. It went down in Gratz. It survived in Grutter by one vote for the law school because they had a slightly more nuanced position. But the justice that gave that majority vote was Sandra Day O'Connor. And she said in writing that the court expects that 25 years from now, the use of racial preferences will no longer be necessary to further the interests today. She said that that even the majority in that case believed that this was discrimination and would not last for 25 years. Now, I must tell you, when she wrote that opinion, I was entirely confused where the heck that came from, because usually constitutional rights don't have expiration dates. And so it just sort of came out of the head of Zeus that, 25 years, this turns into a pumpkin. And I was not alone in that. But it does show that even you had on that day, Michigan's college system go down, and you almost had the law school go down, and only survived because they were willing to tolerate it for a few years. So once again, Queen Margaret's rule kicks in. Those are your darlings. And so let's be honest about it. Now, for Chief Justice Roberts, this has been sort of the culmination of his judicial career in terms of his legacy. Roberts is the ultimate institutionalist and incrementalist. That's why he's a swing with Kavanaugh. He doesn't like getting too far ahead of his skis. That's one of the reasons he was alone in Dobbs. And it's also the reason why this isn't the Roberts court, right? He couldn't even get Kavanaugh in Dobbs. What he wanted to do was exactly what the public polling showed. He wanted to uphold the Mississippi law at like 15 weeks, which is where the public is, and keep Roe v. Wade, because he didn't want to create this schism in the country. But the problem is that was a practical result, but it wasn't one that spoke to the first principles for either side. So both the left and the right said, we don't get that. I mean, how does that answer our questions about, is this a protected right or not? But the exception to this is really on racial discrimination. Roberts has voted against all forms of racial discrimination repeatedly. He has said famously the way to end racial discrimination is to stop racially discriminating. And he finally secured a majority in the Harvard and North Carolina cases. And that was the brightest of bright line rules. The court said the student must be treated based on his or her experiences as an individual, not on the basis of race. Many universities have long done just the opposite. In doing, they've concluded wrongly that the touchstone of an individual's identity is not challenges bested, skills built, lessons learned, but the color of their skin. And he said our constitutional history does not tolerate that choice. And so he ruled with the majority against it. And that certainly answers, it sort of closes out the line of cases all the way through Grutter and Gratz. But then he added something which is going to be the next line of cases. So he said, don't do this. And you got to understand, I think Harvard did an absolutely abysmal job in arguing this case. And I'm usually much more forgiving for fellow counsels, because God knows we've all been in this position. But they didn't have an answer for the court, in my view. As many of you may know, Harvard in North Carolina involved a different sort of context for this issue, because it wasn't racial discrimination involving African Americans. It was a claim being made by Asian Americans. And it in many ways was the perfect vehicle for the Supreme Court, because the Supreme Court had been complaining since Bakke that universities are filled with very smart and clever people, and they had found ways to reintroduce essentially racial set-asides. And the court was very frustrated with that. Harvard was too clever by half. Harvard developed a system where you got ranked on all these different issues. I forgot all of them. I think there were like 5 of them. But one of them was personality. Now, the problem for Harvard is that Asian students were scoring higher on average than other groups. And so if you went on a standardized test basis, GPA basis, you'd have a higher yield on Asian acceptances. So they added the personality category, and they resisted getting this data. It took years to get this out of the cold, dead fingers of the Harvard president. And finally, even the judge, who was very sympathetic, this judge was in favor of racial diversity and disagreed with the ultimate decision of the Supreme Court, even she said, yeah, this is bad. Because what had happened was that they would interview Asian candidates and then give them extremely low scores on personality. And so this category was saying, you know, are you patriotic? Are you nice? Are you conversant? Stuff like, and it turns out that Asians are none of those things. It turns out Asians are just not interesting people. And so Chief Justice Roberts asked the Harvard president that, said, are Asians just not interesting people? Or are they just not patriotic? And the Harvard counsel was sort of sputtering at that point, trying to explain why Asians as a group would score so much lower on personality. And everyone in the room knew why, and that is it was a soft category used to reduce the numbers. And the other problem with Harvard is that the number of admissions seemed to be remarkably constant in terms of how many groups got in and what their racial makeup was. And that was also raised by Robert, saying, is this just the world's greatest coincidence? You seem to have almost the identical number of people that seem to meet your criteria of racial groups like this getting in every year. It's almost like you're fixing it. So in some ways, I think Harvard blew it. Now, this is the really funny thing about it, because if you remember, I told you in Bakke, when Powell said, let's use a diversity plan, he was citing the Harvard plan. So the authority used in the concurrence in Bakke was, I like Harvard, because Harvard makes it just one of the criteria. Now, this was at the time, and it still is, one of the dumbest things he could have done, because using Harvard. Because the Harvard admission plan was created, that whole diversity plan was created to keep Jews out. It was an anti-Semitic rule. And it was because they felt that too many Jewish people were getting in. So citing that as the authority for diversity doesn't really sit well. And by the way, the justices brought that up with Harvard's counsel and said, you know, can we just clear the record for one thing? We've been citing your plan, and it appears that you just didn't like Jewish people very much. So the whole thing was a bad combination of factors. But you now have this clarity, but Roberts added this and said, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And so what basically Roberts did is he said, here's a better idea. Here's how you can consider race. Allow students that have actually confronted racism in any form to tell you about it and to tell you how it's affected their lives. And that is something you can consider. And so that's where we're going to see this move now. And many universities have already shifted. They've done prompts like that. Now, you're going to see litigation coming up where people are going to say, well, you just created prompts, and now the expectation is that universities are going to increase the essay weight and try to achieve the same distribution. And then there'll be more lawsuits. But I tell you, I don't expect the court personally, all of us handicap the court. I don't expect the court grabbing another affirmative action case soon. I think there's going to be a lot of them bubbling up. But this is the type of thing usually the court wants to sort of sit for a while to get a better record. I would expect another major affirmative action case not to come up for 10 years because the court tends to be incrementalist. They tend to wait to see how this goes. So I think that's what you're going to see is coming out of this. Okay. Now, in the meantime, universities are already adjusting this. And one of the moves, by the way, has been a move against standardized tests. And you see at the University of California, they got rid of standardized tests. Even though I'm a big believer in standardized tests, I don't believe you should rely on them entirely. I believe in looking at the background of students. I also believe in diversity in a class. I believe that we should try to create diverse classes. But I do think that the attack on standardized tests is wrong. And what's interesting is that, I wrote a column a few years ago saying the court seems to be inching towards a showdown on affirmative action, and you may have a decision soon saying that all of this stuff is going to stop. And so what are you going to do about it? Well, what Napolitano, the president of the University of California, did about it is she said, maybe we should get rid of standardized testing as racist. If you get rid of standardized testing, it's sort of hard to measure if race is a dominant factor because you don't have an objective standard there to measure it against. And so some people have suggested if we get rid of standardized testing, how are you going to challenge our admissions? But what's interesting, Napolitano created a task force, and the head of task force was the head of African Studies at the University of California, and they studied this standardized test, and they surprised Napolitano because he and the task force came back and said, we actually think standardized tests are good for minority students. That they said what we found out was that standardized tests are the most accurate predictor of how students do in college. And this is part of the problem that I often raise because sometimes our passions lead us to hurt those that we are trying to help. One of the things I constantly tell friends of mine, because I'm an academic, I constantly get calls of people whose kids are going into universities and colleges. And I constantly see my friends trying to push them into different schools, often schools they went to or what they consider to be the better school. And I always bring them up short on that how you do in a school is going to be much more important to your graduate school rather than what the school is. And how you do in that school depends a lot on whether it's a good fit for you. And what we have found is that people with standardized tests, if they are performing at the low end of a standardized test and you put them into some of these schools, they will continue to perform there. But if you put them actually in a different school, a university that more fits that score band, they tend to excel. They tend to do better, and that's basically what the University of California task force found. They found that this is actually a very accurate predictor, and it allows not only the selection of minority students that can do well here, but it also helps students find the right school. Because in the end, it doesn't matter which school you go to as long as you thrive in that school, as long as you do well in that school, as long as you get fully educated in that school. And they said this really helps you. And if you get rid of it, they said it becomes a blind selection, and we're going to have more people doing worse. And so the only reason I mention that is, and Napolitano said, thank you very much, and then she killed the standardized test. But the reason I mention that is, as academics, our obligation runs first and foremost to our students and what is best for them, how to create an environment where they will thrive. I happen to think a diverse environment helps students thrive, and I think it's a very useful and important thing. I also think that it's important to have students in the right environment. In all of these universities, you will get a great higher education. The question is, where will you do the best? And that's what unfortunately, I think is being sacrificed here because it's just too complex to discuss in the narrative, and that's unfortunate. Now, here's where I'm going to make that sharp turn, because I'll note, by the way, that most of the public does not support affirmative action in education, and never has. The reason California did that task force, California, which is one of the most liberal states in the union, has repeatedly rejected the use of race in admissions. And not long ago, there was a huge multi-million-dollar push on a referendum to try to change the earlier referendum banning the use of race, and it went down in flames. It was not even close, which means there's a lot of Democrats that are joining Republicans, a lot of people who are crossing over. They don't want this part of the admissions process. They want students to be viewed as individuals on their own merits. Across the country, it's over 50%. Democrats are more likely, but even among Democrats, only 54% of Democrats support race in admissions. It's basically half. So the other half does not. 75% of Republicans do not. All right. So here's my sharp turn, and please tell me if I'm going over. You can get the hook. What I'm equally concerned about, I think that we are going to preserve diversity in terms of race. I am, personally as an academic, what I value most is diversity in class, economic diversity. To me, I've been teaching for 30 years, and when I have aha moments in my class, it is when I hear from students who come from poor areas, who come from crime-ridden areas of any race. And when they say things in my class, it is a perspective that most of my students have not heard. When we're talking about unlawful searches and seizures, that's a very different experience if you are coming from a neighborhood where that's a common experience, where people are commonly frisked and searched. To me, that diversity should be a priority. Perhaps we'll get more of that as universities begin to redo this. But this brings me to my next subject, which is another priority that I think may have to take even greater efforts, and that is the diversity of viewpoints. I've been an academic for over 30 years. I was raised in a liberal, politically active Democratic family. I'm still a Democrat. And I'm actually, despite what you hear, fairly liberal. I'm socially liberal. I have never thought I would see what I'm seeing in academia today. I don't think I'm a naive person. I never thought I would see the intolerance, the orthodoxy, the hatred, the canceling. I never thought I would see that. Never thought I would see faculty participating in it. Not in I wouldn't believe it. But we are seeing that. And the question is, as we look at the Harvard case and North Carolina case in terms of diversity, maybe we need to consider other diversity as well, including ideological diversity. Now, there's cases that can affect this. And one of the most important cases that came down last year, and probably my favorite case, is 303 Creative versus Elenis. And that case was basically the follow-up to Masterpiece Cake Shop, where you had a baker who said he didn't want to do a cake for a same-sex couple. And the Supreme Court, all of us were waiting, because I'd written for decades academic pieces saying that the court had made a mistake, that we're having this collision between anti-discrimination laws and constitutional rights. And the court took those cases and put them under the religion clauses, which I think, and I've long thought was a huge mistake. And I'm associated with the free speech community, so it should not be a surprise that I felt that it should be under the free speech clause. Elenis was everything we wanted, because in Masterpiece, the court just took an exit ramp. So we thought Masterpiece was going to be it. And so it came out, and it was a total buzzkill. The court took this really unconvincing exception to the proceedings below, and said that this commission in Colorado had shown hostility towards the religion of the baker, which I'm not too sure actually is borne out. I mean, when I read that, and I'm someone who felt that the commission was wrong, I wrote at the time, I actually think this is just one commissioner who said a really stupid thing on one day. I don't think you can say, look at that and send the entire case back, because you don't want to rule on the constitutional question. So Masterpiece Cake Shop was a huge disappointment. And then came 303 Creative. And this involved a website designer. And the reason this case was perfect, and the funny thing is I spoke to the 10th Circuit at their conference when they just handed down 303 Creative. And I thanked the judges for getting that case so wrong that the Supreme Court was almost certain to accept it. And I could hear their grinding teeth. But the fact is that case was so unbelievably wrong that it had to be accepted. And what happened is it went to the Supreme Court, and the 10th Circuit had said this website designer's views in not wanting to do a design for a same-sex marriage is protected speech. So the 10th Circuit said it is protected by the First Amendment. Now that's a huge step. Usually when you say that, the rest that follows is pretty short, right? The rest follows, then you can't do it. But the 10th Circuit said, but it's in conflict with this anti-discrimination law, and the whole, this is a direct, let me get the direct quote because you won't believe me. He said, the whole purpose of the law is eliminating ideas is the very purpose of the law. So let that sort of sink in. Eliminating ideas is the very purpose of the law. And that was the basis of the 10th Circuit ruling. This is why I taunted my friends on the 10th Circuit. So it went to the Supreme Court, and Gorsuch handed down a major free speech victory. Okay? And what Gorsuch said was that the framers designed the free speech clause in the First Amendment to protect the freedom to think as you will and to speak as you think. They did so because they saw freedom of speech both as an end and as a means, period, full stop, and reversed the 10th Circuit. Okay? So why is that relevant to diversity of thought? Within a week of 303 Creative being handed down, the Fourth Circuit handed down a case called Porter. Porter versus the Board of Trustees of the University of North Carolina State University. And in that case, you had a conservative professor who had challenged DEI policies with his colleagues in emails, and he was sanctioned. And he sued. And the Fourth Circuit said, this isn't a denial of free speech because it's conduct, because you were being uncollegial. Okay, so they're punishing you for being uncollegial, not for what you said. Now, putting aside that this case also takes a very narrow view of a case called Garcetti, which deals with academic freedom and free speech among law professors, overall. It is the speech as conduct that is so dangerous about that opinion. I have a book coming out on free speech called Free Speech in the Age of Rage. And it traces our history of anti-free speech movements. And what the book concludes, by the way, now you don't have to buy it, is that this is the worst free speech period this country has ever seen. The only comparison is the Adams-Jefferson period of Alien Sedition Act prosecutions. But I think that this period exceeds it in terms of the damage to free speech. But the damage on campuses is even greater, because this idea that free speech is treated as harm and free speech is treated as conduct. The idea that you can fire a professor for raising objections to your policies for being uncollegial is not a new argument. That was the argument used against African American professors, women professors, Jewish professors. They were all called uncollegial. They were all denied tenure because they were viewed as their conduct was not becoming of a professor. It is a long-standing excuse for discrimination against viewpoints and for classes of people. Porter is very, very dangerous for academics because we could lose a lot. We could lose academic freedom and we could lose free speech protections. And we've already lost a lot. The fact is that we're becoming an echo chamber of viewpoints. If you take Harvard, Harvard was just ranked in the last survey on free speech dead last on free speech. And you can see why. You know, there was a survey done by Harvard Crimson that found that 82% of the faculty identified as liberal or very liberal. 82%, it's actually almost 83%. The number, not a single faculty member at Harvard, not one, identified as very conservative. 1% of the Harvard faculty identified as conservative. This country is divided almost evenly between liberals and conservatives. And yet our faculties have often not a single conservative or just a couple of conservatives. And that has an impact on students. We have seen an increase every year in polling showing students are saying that the vast majority feel uncomfortable sharing their views in class, sharing their views with us. And partially it's because they view us as an echo chamber, as an orthodoxy. That is the thing that kills higher education. We can't survive this way. We can't survive by having a faculty with just 1% of conservatives. And you know, it was funny because the Crimson followed up that poll by interviewing, this is going to sound like a joke, but it's not, the last openly Republican faculty member at Harvard. And he was Harvey Mansfield, age 90. And he was retiring. And these students interviewed him like he was the last buffalo on the plains. And the interview sort of like poked him with sticks to see what a conservative or Republican looked like. And throughout this interview, he's saying, you really should have more diversity. When I came here, it was sort of even. And the funny thing is the Crimson said, well, he's retiring, but it's okay. We don't need Republicans and conservatives necessarily on the faculty to have a good university. What you have then is an echo chamber. And you also have intolerance. So in a Georgetown study, they found nationwide only 9% of law professors identify as conservative. 9%. Now, how does that happen? Is that by accident? Does that just happen? That strangely enough, only 9% of faculty candidates who are qualified are conservative? It doesn't happen by accident. It means that faculty are actively purging their ranks. And I've seen it at faculty meetings. I've seen very talented young conservative faculty members who are not even given consideration. And what that also has led to in this period, this age of rage, is a growing intolerance for the court itself. And I want to just end by talking about that. We are living in an age of rage. You know, Justice Robert Jackson said, we're not final because we're infallible because we're final. The Supreme Court we have to have some point in which the argument ends, not forever. Dobbs can get reversed. Dobbs can be overturned. But we have to respect the institution, and the American people do. The American people are overwhelmingly opposed to packing the court in polls. Overwhelming. And the needle hasn't changed. It's actually gone up. With all of the effort to pack the court, more Americans today than 5 years ago say, we don't want to pack the court. Now, these are Americans that often are very upset about Dobbs, very upset about these opinions. But it's in our DNA We know that we need the court. And yet you have professors, you have a professor at Harvard and a professor at Yale that recently published a piece saying that we have to radically alter our Constitution to reclaim America from constitutionalism. That the problem is constitutionalism. You know, that's what breeds not just court packing, this contempt. You've Erwin Chemerinsky, who I have great respect for, called the conservative justices hacks. Really? You're the dean of a major law school, and because you disagree with how they view the Constitution, they're hacks now. And that's what people hear, and that's why we've had an assassination attempt at a justice. We have all of these threats. So where does that leave us? It leaves us with where Woody Allen once said, you know, I really wish I could leave you with something positive, but I can't. But would you accept 2 negatives instead? And so I'm going to use his advice and give you 2 negatives to make a positive. Okay? Because I am an optimist, no matter how divisive these cases are. And the first negative is that the Constitution was not written in times like these. It was 4 times like this. It was actually written in a time like this. You know, the framers, in the beginning of our republic, you know, I once had a member ask me in a testimony, he said, you know, you keep on talking about James Madison and the history, but, you know, people today want, you know, they talk like they want to kill each other. And I told the member, okay, back then they were trying to kill each other. They were actually trying to kill each other. That's what the Alien and Sedition Act was. They were trying to kill their opponents. That's the period the Constitution was written in. It was written for times like these. It is a covenant of faith that we have. That's why the second negative is that Madison said that you design your system not for the best in people, but the worst. When he said that if all men were angels, no government would be necessary. He didn't have any illusions about what people are capable of. But there's one thing in there, in that magnificent creation of Madison, and it's this idea that this is a crisis of faith. The Constitution is a covenant not between us and the government. It's a covenant with each other. It's our telling each other that we have faith in each other, even when we disagree. It's telling each other that no matter how much we disagree, we are going to protect this thing that has held us together for so long. And I think that Ruth Bader Ginsburg said it best. Now, I began with her and I'll end with her. And I loved Justice Ginsburg. And I particularly loved how she would put things in the simplest and most elegant ways. And I remember she once said, we have the oldest written Constitution still in force in the world because it starts with 3 words, we the people. And I remember thinking that may be the single most elegant statement ever made on the Constitution. That's why we're still here. That's the article of faith. The Constitution begins with we the people because it's ours. It was given to us. And every generation has to protect it. That's why it's in our DNA. That's why the polls show that the American people get it, even if pundits do not. But it has to start here. Universities have to have a tolerance for debate. They have to have something more than just an orthodoxy in an echo chamber. They have to believe in each other enough so that we can discuss these issues as we are doing today. And so I'll end there and thank you very much for this opportunity.
We have time for some questions. We can deal with this. We can let Professor Turley just choose. You raise your hand if you have a question, and I will come to you with the microphone.
And I'll take any questions, particularly sordid questions. Yes.
This isn't sordid, I hope.
Oh.
This problem with intolerance of diverse ideas on campus, can this be solved by the higher education institutions themselves, or must it be solved by them, or is it going to be solved by legal challenges?
Look, yeah. It's a great question. I want to be honest with you because I am not hopeful that we can make this cat walk backwards at private universities. The hope for free speech, and this may ultimately be the hope for private universities, is public universities. That public universities are subject to the First Amendment, regardless of the inclinations of the faculty. They can't stop most speech on campus. And I think what you're beginning to see is that students that want to be in a free speech environment, who want to have a diversity of viewpoints, are beginning to go to public universities more. And they may become our line of defense. And it may put pressure on private universities that you can have these debates at other universities, but your university is not having that debate. And the question is why? You know, when I went to the University of Chicago, I loved it. It was eye-opening to me. It was a transformative moment. You know, I had never met a Republican. I was told they existed, but I lived on the north side of Chicago. Okay, there weren't any Republicans, okay? And so when I first met my first Republican, I was shocked. I called my parents and said I met one. But I came to love University of Chicago because there were so many people with so many different views, and I'd never considered them, most of whom I thought were crazy. But I loved every minute of it. And I actually lived in the Dorchester Cooperative, the oldest vegetarian cooperative in the country. It's where the book The Jungle was written. I actually had his room, which I thought was a great honor until I found out it was basically a closet. But I remember the Spartacus League came to me, and these were Trotskyites. And they said, we need 5 members to have funding as a group. Would you be our 5th member so that we can meet in your basement? And I said, but I'm not a Trotskyite. I think Trotsky was insane, and I think you're insane. And they said, we know that, but you always come to our meetings. And I said, yes, because I mock you. And he goes, we like that. We have great debates. And we met in the basement, and I went to every one of their meetings because I thought it was fascinating. I wouldn't just mock them. I actually was sort of interested in how people could see something very different from myself. That's why I feel so sad for students today, is that you don't have that. You get this very narrow band of viewpoints from faculties today, and it arrests your own development, you know? It's not that it would make you something you're not, but it would add depth to who you are if you actually thought and heard and interacted with people not like yourself. Do you have another hand? Looking for something sordid, something sensational?
Hello, very good talk, thank you. I'm Enrique, I'm a senior, and I just, this is probably gonna be a very tough question to answer, but what has led to this echo chamber culture that we see now in America? You talked about your time at U Chicago, I'm guessing it was 30 years ago.
Thank you. Yeah, 30 years ago.
But what has happened since your time talking with the Trotskyites to our time now?
That is a really good question. You're right, it's hard to answer because I've thought about it a lot. This is the saddest part of my life, is watching. I love the fact that I'm an academic. I've been honored to have this privilege to teach students. It's the greatest privilege of my life. I have a lot of different jobs, but there's no job that I value more than teaching students. And so I'm very sad about it. I actually had a student come up to me who was graduating, and she said, I just want to tell you something, because she was in my Supreme Court class, and she said, this isn't to compliment you, it's just, I wanted to tell someone. She said, I've gone through 4 years of college, and I've gone through 3 years of law school, and your class was my last class in law school, and that was the only class I have ever felt comfortable expressing my viewpoints. And she said, I didn't realize that till the end when I wrote the paper. And I remember when she left, I was so depressed that she had been denied something really special. You know, she'd been denied something that most of the faculty today that is limiting diversity of viewpoints had when they went to college. So what caused it? There was a tipping point that was reached on faculties. And when I was at Tulane, I fought to get a critical feminist on the faculty, not because I agreed with her, I did not. But I fought to get her on the faculty because I wanted my students to have that viewpoint. I thought it would be really important for them to hear critical legal views and radical feminist views, and I thought she was a very good academic. I never thought that same person would, and unfortunately she did, become someone who actively purged the faculty of conservatives and moderates. I don't know how that ideology led to that. But there's a lot of, it's not just that all the faculty members are part of one group. I'm most critical of what I think is the majority of faculty, and that's faculty who are just silent. I think that what happens is you've got a core group that's big enough that they can take over committees. And when they put forward this stuff, nobody wants to risk being tagged and being subject of a cancel campaign. So most of the faculty is silent. Now, you also have to keep in mind, most faculty today are contract faculty. So to fire me, I'm a tenured faculty member, and there's been a campaign to have me fired for 30 years now. And it's never stopped. It was after I testified in the Clinton impeachment. It started then. It's gone every single year to get me fired. But it's sort of hard to get me fired because I'm tenured and I'm a chaired professor. And I'm also sort of stubborn. What they don't realize is I'm Sicilian. And as a Sicilian, the more they try to fire me, the more intent I am to die at my desk. That's just to piss them off by just lingering. And so they'd be much better if they just were nice to me. Then I'd be like, I'm getting a little tired of this. So I don't know why, but I think it was a combination of numbers and this ideology. But it really is, in my view, only about 35% of the faculties. Most faculty are very, very liberal, but there's a core that is very, very intolerant, and they tend to control a lot of that. Mm-hmm.
Hello there. Yes, I have a question about the affirmative action decision. So, as you said, John Roberts has been very steadfast in his views opposing any forms of racial preferences, and he's consistently said that. But this one line that you read from his opinion about how colleges could potentially consider race in these essays, that seems to be the opening for universities to do essentially what they might like. So John Roberts, who has had very consistent views, why did he put that line and make potentially a very strong opinion into a wishy-washy one?
Well, I actually agree with the line because I think that is part of a student's identity, right? What we're looking for is to understand the student. And if a student has overcome racial discrimination or discrimination against gay or lesbian individuals or any form of anti-Semitism, that is an important part of what that student is. It is an important part of what that student has faced. I mean, when we look at students, we're looking at a band, students within a band of objective scores usually. And within that band, you're trying to select students that you believe are going to bring a value added to the class. And if you have a student that faced adversity of any form, I do want them in the class. I want other students to hear about that experience. So I don't disagree with the line. And I don't think that Roberts has any delusion about what universities will do. That's going to be the next round. And there's a couple of ways that we'll be able to see if it's being, again, too clever by half. One is if these essays get doubled in their weight on the application process. And then that's a pretty good indicator. But second, it's going to be looking at the racial makeup of the class. If it's like Harvard and it just stays constant every year, you're going to sort of wonder how that happens, you end up with the same number of people in racial groups. And I think that's what we'll look for. Mm-hmm. Oh, we got more questions. Do you want to pick? I don't feel like I can do a Sophie's choice here. Hi.
I'm Luna, I'm a freshman here, and I just had a question on how, like, I know you said the SAT should still be kept and things like that, but also prioritizing economic diversity, and I'm not certain on this, but isn't there a correlation between wealthier students doing better on the SAT? So how can we keep a balance between keeping the SAT but also prioritizing economic diversity?
That's an absolutely fantastic question. And you're right, that the standardized test can certainly favor more affluent students. And that's the reason I've written before that we need to take a lot of the funds that we're using on this elaborate system to sort of hide a racial quota, use that money to actually fund areas to help train students for the SAT in our public schools. I'm a huge believer in public schools. I send all my kids to public schools because I believe they play a big role in our civics. But I believe our public schools are failing miserably, but they are failing minorities and poor people the most. And I think when you look at New York and Baltimore, it makes me want to throw up. Because if I'm a minority parent in Baltimore, I had so much respect for this one woman 2 years ago who's African American, and her son was graduating in the top 50% of his class, and he had only passed 1 of 14 classes. And when she found out about it, she said, "Don't pass my son. I don't want you. You're telling me you're going to send my son out there. You failed him. Maybe I failed him, but you can't say that he has a high school education right now." To me, it is such a tragedy, and it doesn't have to be that way. And one of the things I would do is pump money into prep courses for SATs, and just to make sure that kids can have as many of those courses as possible. And the weird thing about that is it's not expensive. It's actually not. SAT courses you can actually reproduce at relatively small cost in comparison to the other stuff we're doing that can have a huge impact on these students. So I believe that's where we should shift the money. But it's a great question.
So Professor Turley, you mentioned the court and their substantive agreements and disagreements. So my question is, there's a lot of disagreement about how to interpret substantive due process. Do we follow Glucksberg or do we follow Obergefell? So do you think the justices are going to continue to follow the Glucksberg path, or do you think we're going to kind of rein it in and keep it solely for Dobbs? Yeah,
I got to tell you, I think that's going to be, that's one thing that no one can answer. First of all, with Obergefell, I think that what we're beginning to see is that Kennedy's dream of a dignity-based right is not going well, including with with liberal colleagues. So that whole aspect of earlier decisions, I think, is beginning to wane, because what Kennedy was trying to do is create a new foundation for these rights that he called a right to dignity. In terms of the Dobbs analysis, I actually was not won over by how the Supreme Court ruled on Dobbs. I think that there was some, a better understanding that could have been raised as to those opinions. I think that it's going to evolve, but I don't think that when you look at the cases coming up, there is a sort of federal footprint a little bit. I mean, one of the questions is what federal right to abortion still exists? To what extent does the Constitution still protect abortion? There's some cases bubbling up on that, but most of these are going to come out of the states. And as you know, the Supreme Court tends to allow state Supreme Courts to have the greatest say on what their constitutions mean, as long as they don't violate the federal Constitution. So I think that we're going to see a lower number of those cases coming forward. So it's a good question, but I can't answer it, and we'll have to see what comes down the road.
Professor, we return to the question of how it happened. Specifically, I'm surprised that faculty, even in the majority, had the power to control things like hiring. It surprised me. Do you have a comment on the role of the boards and funders in this role?
Oh yeah, I mean, first of all, for private universities, the only hope for free speech are donors. the only hope for free speech is for donors to say, I'm not giving you money if you don't allow students to have a full range of different viewpoints and to have faculty that are diverse. University presidents are not really complex individuals. I'm not referring to deans, who are wonderful people and cut from the best of cloth. Yes, but when university presidents are craven, horrible people, and they respond to one thing only, and that is money. I've had a number of them. And the only thing I can say for sure, I've seen them from the left and right, is that it is money. If you shut off money, things happen. The state universities are the most obvious. And I've gotten a little heat from some, because I believe the faculty should still control appointments. But I got heat from a lot of my colleagues because I wrote a column saying, but why should a state continue to fund you when you reject the viewpoints of at least half or more of that state? You won't hire someone that shares those values. Since when did they become a captive audience that the taxpayer has to just keep on funding you as you exclude half the values of society? So I think that state legislators can say, you know what, if you have just one conservative and one Republican, don't tell us this is an accident. And we're going to reduce your funding. And then if you can go out and get liberal donors to fund an echo chamber of just liberal faculty, then go do it. And you can stay a state university, we'll give you basic funds, but we're not going to give you all the funds. They need to do that. I got to tell you, my phone just melted when that column came out. But I am unapologetic. I think that public universities are the thing that may save us. And I think that state legislators should get busy. And I think that if we can make state universities bastions of free speech, it's going to affect private universities. Those donors are going to start to say, how come they have all these interesting debates over at the University of Illinois, but we don't? I mean, at my school, the debates run from the gamut of A to B. We had, when the Dobbs decision came out, the faculty did a public panel on just why the Dobbs decision was wrong. There was literally no one on the panel that was there to suggest that maybe it might be right.
For our last question.
Thanks for your talk. You talked about the college essays. The other thing from the recent Harvard UNC case was they said that it wouldn't apply to military academies. And as you probably know, the same group, Students for Fair Admissions, has just filed a complaint against West Point. They don't have, as far as I can see so far, they don't have all the same details in terms of like the scoring and all of that. But they do have a document that shows that West Point is quite consciously trying to meet, I think, what you call quotas, fairly, for different racial groups and other groups as well. So I'm just wondering, first of all, why the court didn't deal with the military academies in the Harvard UNC case? Like, why did they explicitly say this doesn't apply? And what do you think the chances of a complaint succeeding in terms of getting rid of affirmative action for the military academy?
That is a great question. And I have to say, when I read Dobbs, I was doing the coverage. And so those are always the scary moments because you have to do coverage and you're on live television and you have to announce the result. And they're very supportive, except if you get it wrong, you'll be fired. That's how Roger Cossack. When I worked for CBS, we had the Gore decision, the presidential decision come down. And I remember Dan Rather saying, I want to be first. And I was like, okay, Dan, I just come from NBC. And I said, how you intend to do that? And he said, we're going to stay at the desk and then we'll be live. And so when Bob Schieffer had the opinion and he came out with his floppy ear hat out to the front of the Supreme Court and and the idea was that the vice president of CBS was reading the opinion in one ear and I was talking to Dan Rather and Bob Schieffer with a producer in my other ear. And the idea was that once I felt pretty good how the decision came out, I would touch my nose. And so and in the back were all the cameras of all of our competitors to see who was going to call it first. And I finally touched my nose, and we called it. and I called it for Bush, just as Roger was calling it for Gore. And that was the last we saw of Roger. But the reason that story comes to mind is because when Harvard came out, the line that stuck out to me as I was trying to read through it as fast as I could on the air was that line. I mean, you were absolutely right. There's a couple of reasons for it, I think. I actually wrote a series which I called the American Military Pocket Republic. And it was a sort of a history and legal study of the development of the military, the American military, including its legal basis. And it's really, really interesting. The Supreme Court, after the Civil War, and it was entirely composed of Civil War veterans, including 2 justices that tried to kill each other. Actually, one justice tried to shoot the other justice when he was crossing a river as a Confederate private. It's the only known case of a justice actually trying to kill one, as opposed to regularly, figuratively trying to kill each other. But they all had this deep-seated belief in the military. And what came out of that was this line of cases in the Supreme Court, which is a separate line of cases that honors the military as having good conduct and discipline as a unique sort of culture. That was what came out of these early cases. I think that Roberts was nodding to that line of cases, that he had enough heavy lifting going on that he didn't want to confront that line of cases involving the deference given to the military because of all those cases. So my assumption is he just wanted to minimize the lift, and he put that in, but that's my guess.
Thank you very much for.
Thank you all very much. Thanks.